As you are listening to our podcast, please remember we are not giving legal advice. This is for informational purposes only. If you need an attorney to help you, please reach out to an attorney within your jurisdiction. May it please the court. My name is Rwan Saffarini Hardesty, and together with my co-counsel Jason Larman, we represent The Appeal of It, a podcast designed to distill Texas Supreme Court opinions, Texas Court of Appeals opinions, and other Texas law to make it all more appealing.
I'm Jason Larman, and I'm here with Rwan Hardesty, and you're listening to The Appeal of It. Today's episode is on informal marriage, or as you may have heard it referred to, common law marriage. In Texas, we don't have common law divorce. We just have divorce. So if you've been formally married with a marriage license and a ceremony and all of that, you go through the divorce process should that relationship end. But we also have informal marriage, or common law marriage, where you may not have had a license, you may not have had the same formal ceremony, but the process of ending that relationship is the same. Those are much more nuanced, and there's a lot of questions that come up about whether a relationship is a marriage or not. And that's what we wanted to talk to you about today.
So I'm going to talk a little bit about what the history in Texas is with common law or informal marriages, and then go into the most, the case that is the one that most Court of Appeals hinged their opinions on to begin with, and then we'll go into some of the issues on how, or some of the ways on how to prove common law marriage or to disprove common law marriage. So in Texas, common law marriages have been recognized since about 1947, and although Texas rejected the need to have a formal marriage to establish a legal marriage relationship, it was kind of a grudging acceptance of common law marriages, essentially. They tolerated informal marriages, and by the point that we reached 1970, the Texas legislature started receiving pressure to abolish common law marriages. At that point in 1970, there was a statutory change, and although they had this pressure to change common law marriages and to actually abolish them, they refused to do so. And instead, they added basically a provision that said, if couples want to prove that they're married, they can sign what's called a declaration of marriage and file that with the court. But they didn't have to do that. They could still try and prove their informal marriage through other means. It wasn't until 1989 that there were some more pressures towards the legislature that said, we don't want common law marriage here in Texas. But again, the legislature didn't abolish common law marriage, but they did make it more difficult to prove. So prior to 1989, there was language in the statute that said inferences could be used in order to prove an informal marriage. After 1989, they took out language that talked about inferences. And so by the time that we get to 1993, there's a case that goes up to the Texas Supreme Court. Let me try that again. By the time we get to 1993, a case makes it up to the Texas Supreme Court that discusses how you are to prove an informal marriage. That case is called Russell v. Russell. It was decided by the Texas Supreme Court in 1993, and it's actually a case that consolidated two cases together. One out of the Ninth Court of Appeal, which is the Beaumont Court of Appeal here in Texas, and the other out of the Fifth Court of Appeal, which is the Dallas Court of Appeal in Texas. So Russell v. Russell is what we call it, even though there are two cases kind of consolidated here. And in Russell v. Russell, let me kind of go through some of the facts. The Russells were married through a marriage ceremony in Texas in 1981. But before their ceremonial marriage, they lived together, or basically they cohabitated on and off from approximately 1964 until 1981 when they had their ceremony. They had 5 children, And the husband acknowledged these facts on the record. And the wife basically said, based off of these facts, we were married back in 1964. So the trial court in that case said there was an informal marriage. And the Court of Appeals affirmed the trial court, saying the trial court was right. And informal marriage can be proven by both direct evidence and circumstantial evidence. The parties had represented to others that they were married, and they lived together in the state of Texas. So because of those facts, the Court of Appeals affirmed. And then it was taken up on appeal to the Texas Supreme Court. The second case was Lawrenson versus Weber. And the parties here began cohabitating in 1982, but they had to move frequently because of Mr. Lawrenson's job. So in January of 1991, the couple separated and Miss Weber filed for divorce. The trial court found that they were informally married in 1982, but the Court of Appeals here held that there was no evidence that the parties agreed to be married, and reversed and rendered the trial court judgment, and basically said, we don't believe that a valid marriage existed. So then that decision was taken up to the Texas Supreme Court. And that's where we find ourselves here in the Texas Supreme Court. Now, before I get into what the Texas Supreme Court said, I wanted to kind of have Jason talk a little bit about what circumstantial evidence is and what direct evidence is, because it'll inform a lot of what we talk about in this case and how the Texas Supreme Court got to where they got.
Okay, so this is a question that comes up a lot. It comes up in all kinds of different contexts, and sometimes criminal cases are the easiest way to explain it. So if you think about a bank robbery, you'd have potentially security footage of someone wearing a ski mask, holding a gun, robbing a bank. That video evidence is direct evidence because it shows the thing you're trying to prove directly. Circumstantial evidence would be evidence that's essentially one step removed from that. So maybe it's security footage of that same person carrying a bag of money, wearing a ski mask, running through the parking lot, or things like that. It's not that it's not valid evidence, and it's not that it's not believable evidence. It's evidence that requires you to make some inference from the evidence to the final destination that you're trying to get to. So everybody tries to sort of make that distinction in terms of the law, but the reality is it's all valid evidence. Some of it just requires other pieces of the puzzle to fit together in order to get you to your conclusion.
So the statute itself says that in order to be informally married, that the couple needs to first agree that they are married, or they agreed to be married is actually how the statute reads. And after the agreement, they live together as husband and wife, and then they represented to others that they were married. So when it goes up on the Texas Supreme Court, these two cases went up to the Texas Supreme Court, the issue came up as to whether the parties had to prove each element with direct evidence or if it was through circumstantial evidence. And the reason for that, again, is because the 1970 statute specifically talked about inferences. And it said that the agreement of the parties to marry, which is the first element that I just said, may be inferred if it's proved that they lived together as husband and wife and represented to others that they were married. And then that language was taken out in the 1989 amendment. So ultimately, so that we can kind of go through everything, the Texas Supreme Court held that an agreement to be married could be proven by circumstantial evidence, but they don't just end there. So in family law cases, there has to be a finding that there's enough evidence to support a common law marriage exists. So the Texas Supreme Court ended up reversing both judgments and remanding them both to trial because they wanted the courts to figure out if there was enough evidence to prove common law or informal marriages. the Supreme Court case was decided with 6 justices joining in the opinion, which meant that those 6 justices agreed with the ultimate outcome, stating that circumstantial evidence could be used to prove informal marriage. And then we had 2 justices dissenting. So we have a 7-2 split. So if you ever hear what a 7-2 split or a 6-4, 6-3 split or anything like that, that's what it means. Some justices are agreeing with an opinion and some are dissenting to the opinion. So the dissenting judges essentially said, because the statute prior to 1989 allowed the existence of an agreement to be married by the inference of holding out, which is holding out to other people that they are married, and cohabitation together, that when the legislature deleted that provision later, they indicated a clear intent that inferences should no longer be allowed. So basically the dissent said that the court, the majority court, overruled the legislative intent that there must be proof for rather than inferences. So basically what the dissent said is the majority court overruled legislative intent, and that there must now be proof since the legislature took out the inferred language from the 1970 statute when they amended it in 1989.
All right, so just to make sure that I'm following and that hopefully anybody that's listening is too, in the olden days, back in the 70s and before, Texas had 3 requirements for common law marriage: that you had an agreement to be married, that you lived together as husband and wife, and that you held yourself out as being married. And if I'm following you correctly, back then, if you had proof that you lived together as husband and wife and that you held yourselves out as being married to other people, that those 2 by themselves proved the first one, that you had an agreement to be married.
Right, prior to 1989, correct.
Right. And then the legislature came in and they changed that law and said, no, you can't use those as proof of the first anymore.
Right.
And what the Texas Supreme Court had to decide, and what they ultimately did decide, is that you can still prove those with circumstantial evidence, right, with the guy running away from the bank with the bag of money, but just the mere fact that you held yourself out to be married, or that you lived together as husband and wife, by themselves wouldn't prove that, even if a lot of the facts could be used to make those same inferences.
Correct.
Is that correct? Okay.
Yes. And so now when courts are looking as to whether somebody is informally married, they have to do basically an analysis of all of the facts in that specific case. There's no single bright line rule or set of facts or type of situation that definitely, if you have this, then you have an informal marriage, or if you don't have these things, then you don't have an informal marriage. So
well, outside of the 3 core elements, right? How you prove those depends on everybody's circumstance, because again, it's informal marriage, it's common law marriage. Lots of people do it differently. So you're going to have lots of differences in the way people live their lives. Some of them qualify, some of them don't.
Right. And so what I wanted to do was talk about each of the elements kind of in silo, and then talk about things that have helped courts get to the point that they believe that there has been an informal marriage, or vice versa, that there hasn't been a informal marriage. So the first element is that the parties agreed to be married. This actually means that you are agreeing to be married in the moment. That's not being engaged or agreeing to be married in the future, but rather we are immediately, as of this moment, married.
So it's the agreement to be married is the language, but it's essentially you're drawing a distinction there, it sounds like, between an agreement that we're married and an agreement to get married. Is that
Yes.
is that where the line is?
That is where the line is.
So an agreement to get married doesn't get you across the line, but an agreement that you are married does.
Yes.
Okay.
So basically, an engagement doesn't account, and this is an intent element. And what that means is the parties both have to intend to be married in that moment, that they both agree that they are married. So, yes.
So one half of the pair can't say, oh, we're married, unless the other half agrees. So there has to, at some point, be some communication about this, I would assume.
That is where we get into the evidence, direct and circumstantial, as to whether they actually had this discussion.
Okay.
So typically, there are situations where some people may present that they are married to the outside world, but may have an inside discussion between them that says, we're only doing this for, for the fact that we don't want the woman to be embarrassed that she is living with this guy.
Could be social stigma,
Right.
Religious preferences, not disappointing their parents.
Right. So there are a lot of reasons why people would externally say we're married, but internally have an agreement that they are not. And typically that does come about in the religious context. But as we are currently in a state where courts are more willing to understand that people cohabitate together without being married, there actually has to be this element of intent. We are married today, for sure. So when people say that they have this agreement to be married, and one says in court, no, we never had this agreement, and the other says, yes, we did have this agreement and we represented ourselves that way, what comes about is the reason why one person thinks that they were married and one person doesn't. So a specific case that highlights this situation is that there were two parties, that there was an allegation that there was a common law marriage, and one of the parties testified that the two had an understanding that the woman was going to represent herself as the wife for the purpose of avoiding embarrassment to their family until the two got married, kind of like what we just previously discussed. And the Court of Appeals in that specific case found that this was merely an indication to marry in the future. Typically, then we kind of look at, references to each other as to whether we are married or not. Sometimes we have informal references to other people that we may be married, or even amongst the couple that, I'm going to call you my husband because it's just easier, rather than, whatever pet name you may have for your relationship or partner. But ultimately, there has to be a meeting of the minds. So when you get to a court of appeals or even a trial court, you have to be really careful, because if there's a direct challenge that one person did agree to get married and the other person said that's not what our understanding was, then courts start looking at the circumstantial evidence of the other two elements to see if there was some sort of meeting of the minds. Now, typically this comes up in probate matters, not so much in family law matters. So in family law, we typically are in the midst of a divorce, where one party is saying, I was married, and the other party is saying, we were not married. And you have all the evidence that comes in regarding this agreement. In probate matters...
Now, probate matters is after one of the people has died.
Yes.
So this would be like carrying out their will, or, if they die without a will, we're talking about dividing assets and things like that. Mm-hmm. And I'm assuming the big disadvantage there is that there's one person you can no longer talk to ask the circumstances around that relationship.
Right.
Okay.
And so ultimately, a lot of the probate courts find that if there is one party, the person that's still alive, saying, no, we had an agreement to be married, that's almost enough, even if there is a bunch of circumstantial evidence from other people testifying, family members testifying on behalf of the decedent, and the decedent is the person that has died. Even with other evidence of testimony and things like that, if you have the person that's alive saying, no, we had an agreement, it really becomes a difficult burden to overcome. And so courts typically will find that the living spouse is a spouse. So that's an unfortunate turn of events when it comes to specific cases. But again, in family law cases, it's more, of a attack between the two and who's more credible, essentially. The next element is cohabitating, which is living together, but not just cohabitating. It's cohabitating as husband and wife. There are a lot of people that live together for various reasons, especially today. Finances, you may have children together, but you don't want to be married. You don't necessarily commingle your funds or anything like that. But courts do find that this is one of the easier ones to, meet the element of cohabitation. And some of the facts or factors or types of facts that would help in proving this is not only just living together, but leaving something at somebody else's house, like a lot of personal belongings, clothing, things that you would normally have in your garage, like tools and, all of your lawn mowing equipment, things like that, as well as, just being at each other's houses a lot. So the other thing about cohabitation is it doesn't necessarily have to be continuous. So if we have parties that one person stays home and the other one has maybe an oil job, that they're out on the field week on, week off, or a few days on, a few days off, or even like firefighters, they have a 24/48 schedule, so they may be living at the firehouse for the 48 hours or the 24 hours and living at home for 48 hours. So the continuation or the consistent living together isn't a piece that we really have to worry about. They just have to cohabitate in some way. Do you have any questions about that?
Does the agreement to be married, the first requirement, have to happen at the same time that they're cohabitating?
So the cohabitation has to occur after they have agreed to be married.
So, theoretically it could happen at the same time, right?
Sure.
So, but there has to be like a specific day and time that you can point to where both the agreement to be married and the cohabitation existed, right? You can't have one in January and one in June and have no overlap between them. Is that right?
Right. So
Okay.
you can't have, that was a little vague, but so you can't have your agreement, or you can't cohabitate in January.
Stop cohabitating in May and then agree to be married in September.
Right.
Without then cohabitating again.
Yes, in Texas. You have to
Right.
cohabitate in Texas too. That's the other piece.
Okay.
So, but yes, you can't have cohabitation. You cannot have the cohabitation element met unless you have agreed to be married as well.
Both elements have to exist. They don't have to start at the same time, but they do have to exist at the same time.
Yes.
Okay.
Yes. All right. So courts, again, like I said earlier, they're starting to find that cohabitation alone isn't enough because people live together all the time now without establishing marriages. But again, you need to be very careful when you do live with someone that you don't hold yourselves out as being married, which is the third element, which is the holding out or it used to be called holding out. We still use that phraseology, but it basically is representing to others that you are married. And this is an element that is very fact intensive, because there are things that people do in their private lives that are very different than what other people do in their private lives. And that includes things like how they manage their money, or how they spend their time together, or how they buy property and other assets. So this really goes to the court looking at a few different things to figure out if people are actually holding themselves out as married. Now, first, this is a reputation in the community, and not just privately telling, say, our very close friends or our family, hey, we're married. It has to be something that the community at large would consider the two of you married. So if y'all go out and represent to random people that you're married, occasionally, that's one thing. But if you're regularly and consistently telling people out in the community that you're married, that could be you holding out. So this comes up a lot in churches. Like if you go to the church and represent to the congregation that you're married, the church is your community in that sense. And so they would, if you were to go to trial on this issue, you would probably, if you're trying to prove a marriage, you would probably pull people from the congregation to try and say, yes, they held themselves out as married. They told us all that they were married. They joined our church as a married couple, things like that. So, that is kind of how you get to the reputation in the community. But you have to consistently conduct yourselves as husband and wife in the public eye, or the community views you as married. Questions on that? No? Okay. Again, actually telling people that you're married is something that can be used as part of the proof. References to each other as husband and wife. Purchasing property together. This is a huge one. Typically, for those of you that have purchased property, when there's a deed of trust, there's a line that says who's buying the property, the borrower. And that typically in Texas says something like, if I were to buy the property now, it would say Rwan, Hardesty, a single or an unmarried woman. Either way, it would be listed in that deed of trust because I'm buying the property by myself. Or if I were buying it with somebody else, it would say that we were each unmarried if we were not married. But if two people are married, or they represent to the mortgage company that they are married, that line would say both of their names, a married couple. So a lot of times what we find in these appellate decisions in the trial courts is somebody will come and say, I bought all of my property as a single person, and here are all the deeds that say I'm a single person. So I have been representing to the community that I am single. And regardless of what has been said amongst the private people in our lives, we're not married. You look like you want to ask me a question. No? Okay. The other issue that comes up in a lot of these trial courts and the appellate courts is, or some evidence that comes in the trial courts and appellate courts, is tax returns. If you're filing jointly married, or married jointly, I don't know which way it is.
Married filing jointly.
If you're filing married, filing jointly, that is representing to a government agency or to an outside agency that you are married. But if you're filing single or head of household, which is typically a single designation, that would be representing to the community and the government that you are a single person. Having joint bank accounts is also a big point that is brought up in a lot of these cases. If the money that you are making are just going into a joint account and you're commingling your money and you're, using that money as if you were a married couple, then that could go against the argument that you are not married. Typically, people that are not married don't have joint accounts. They have separate accounts, and they put their money in their separate accounts and will use those accounts how they wish without any oversight from the other person. And then obviously purchasing assets together, vehicles together, other property together, representing to loan companies or banks that you all are married. So these are ways, or these are facts that can either go against or for any given circumstance. But the more you have of these items, and these are kind of the big ones, there's a lot of nuance when it comes to whether somebody or a couple holds themselves out as married or not. But ultimately, the more items that you have that kind of prove one way or the other, the more likely, a marriage will be found, or the holding out element will be found and or not be found. Ultimately, though, when we're going to trial in family law cases specifically, trial judges have wide discretion when it comes to whether a specific witness is credible or not, meaning whether they believe them or not. And so when there's just testimony, that's a credibility issue. Does this judge believe what this person is saying over the other person? So when I'm talking specifically, do we agree to be married?
Right. One spouse or purported spouse might say, we had an agreement, and July 15th, 2016, we sat down and we had this conversation at the kitchen table, we agreed to be married. And then you have the other spouse, at least in a contested case, the other spouse may come in and say, that never happened, we didn't even own a table in 2016. I don't know what she's talking about, or I don't know what he's talking about. The judge ultimately has to just decide who to believe, right? Because one of those cannot be true.
Right.
And so the judge has to just make that determination. And I think where you're going with this is that when it reaches a court of appeals, they're typically not going to want to disagree with who the trial court chose to believe, as long as there was at least some basis for the trial court to have believed whichever witness or witnesses, or which parts of witnesses' testimony they chose to believe.
Right.
Okay.
And so they basically, the courts of appeals say, as long as there's a scintilla of evidence that they were, that they could believe, or that this person was credible, then they won't typically overturn a trial court's decision as to who they believed. But, because trial courts' determination of witness credibility is one thing that can't really be overturned, when we look at all of the factors or all of the facts in a factual sufficiency type of situation. Did the trial court have enough facts to prove this element? Then they can see whether or not there was enough to get to what's a preponderance of the evidence, which is more likely than not, more than 50% kind of is the way that we talk about it in law. And so, when I'm talking specifically about holding yourself out, that element, the more facts that weigh in your favor help when it gets to a court of appeals, specifically to that element. The rest of it it just depends on where the facts lie. And again, these are all very fact-intensive cases, and no one case is really the same. So it's very hard to come up with these bright line rules as to whether y'all are married or not.
All right, so real quick, anybody that stayed with us this long that's not a lawyer and might be in a relationship like this and just wants to, maybe they're considering ending the relationship, maybe they're just curious. Is there something those people can do today while they're still in a relationship to either ensure that it will be treated as an informal marriage or to ensure that it will not be treated as an informal marriage, so that their intent in that relationship doesn't become a subject of sort of a he said, she said situation years from now?
Sure. There are two things that family lawyers will typically advise. And again, we aren't here giving legal advice, but definitely go talk to an attorney that is in your jurisdiction. But there are two forms that can be filled out. Well, one is a form, a declaration of informal marriage. You can still do that. You can file it with the court and say, yes, we were married on this date, if you have that intent.
And that effectively means that you guys were married in terms of the law.
Right.
Okay.
Right. And this is hopefully before you've decided to go on to quote unquote divorce or end the relationship.
Ideally.
You would do this. Right. The other thing that a lot of attorneys advise if you are going to cohabitate with somebody is to enter into a cohabitation agreement. And that discusses all of the things about how you will deal with money issues or the finances of living together and what that means. And in that, it specifically will say something like, the intent of this is that we are not married and that we won't be married unless we have a ceremonial marriage. And but the language can be changed, and each cohabitation agreement is very specific to the circumstances that you may be in.
So a very, very precise roommate agreement, in essence, right?
Yes.
You're defining the rules of the relationship in a way that sort of puts everything on paper so that there's not this dispute about what was talked about or what the agreement was down the road.
Correct. So definitely if you are thinking that you want to enter into a cohabitation agreement or a declaration of informal marriage, you should go talk to an attorney in your area that deals with this. Typically it's a family lawyer that deals with these, and that way you can ensure that your marriage or non-marriage are preserved. And because once you get to a trial court, it's really up to who the trial judge believes, unless there is so much evidence that would overcome the thought that you may be married or that you have met, so much evidence so that you cannot meet one or all or some of the elements. And again, just to go over what those elements are, it's an agreement to be married, cohabitating as husband and wife, and then holding out or representing to others in the community that you are a husband and wife. So hopefully that helped. Otherwise, it's just clear as mud because you really don't get a whole lot of instruction from the court since this is a fact-intensive situation. But definitely protect yourselves if you can, if you're in one of these situations. And we'll see you next time.
Thank you.
As you are listening to our podcast, please remember we are not giving legal advice. This is for informational purposes only. If you need an attorney to help you, please reach out to an attorney within your jurisdiction.